Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the Presidential Order amending the Constitution Order of 1954 which applies to the state of Jammu and Kashmir. So now if you look at the current affairs, the Centre's executive order, that is the Presidential Order amending the Constitution application to Jammu and Kashmir Order of 1954 is now challenged in the Jammu and Kashmir High Court. So this order has been challenged in the higher judiciary in the Jammu and Kashmir. So in this context we will have an understanding about the evolution and the purpose of the 1954 order and the disputes related to it. But before we begin, this is our channel StudyIQ and we are providing pen drive courses for various competitive examinations including SSC bank courses, UPSC optionals, SSC JE courses, teaching examination, railway examination, defense examination, RBI grade B, NABARD grade A, UGC NET, UPSC Civil Services Examination, CLAT exams for various state PSCs and also for various professional courses. You can visit our website www.studyiq.com for more details or you can call to any of these numbers for more information. Now let us understand what is the executive order of the President. Now the Union Cabinet recently approved the proposal of the Jammu and Kashmir Governor's Administration in order to amend the Constitution application to Jammu and Kashmir Order of 1954. So after the approval of the Union Cabinet, President Ramnath Kovind issued an executive order in order to amend the 1954 order. So you must understand here that the process is like this. The Governor's Administration in Jammu and Kashmir had proposed to the Union Cabinet in order to amend the Order of 1954 and this proposal was accepted by the Union Cabinet, and on the recommendation of the Union Cabinet, the President Ramnath Kovind has issued an executive order amending the 1954 order. Now coming to the objective of the amendment. The objective was to extend the provisions of 77th and 103rd constitutional amendments to the state of Jammu and Kashmir. So what is the 77th and 103rd Constitutional Amendment Acts? First, the 77th Constitutional Amendment Act, which provides scheduled caste and scheduled tribes, that is SCs and STs, reservation in promotions since 1955. So the 77th Constitutional Amendment Act provides scheduled caste and scheduled tribes in the country a reservation in the promotions, and this was discontinued following the judgment in the case of Indira Soni, wherein it was held that it is beyond the mandate of Article 16(4) of the Constitution. Subsequently, the Constitution was amended by the Constitutional 77th Amendment Act of 1955, and in the 77th Constitutional Amendment Act, a new clause was inserted in Article 16. So, the new clause which was added to Article 16 of Indian Constitution will enable the government to provide reservation to SCs and STs in promotion. So, since 1955, scheduled castes and scheduled tribes have been providing reservations in promotions, but this was discontinued after Indira Soni case, and following the case, the Constitution was amended by 77th Constitutional Amendment Act in order to provide promotions to scheduled castes and scheduled tribes. So, in short, we can say the 77th Amendment Act will provide reservation in promotions to scheduled caste and scheduled tribes. Now, the 103rd Constitutional Amendment Act. The Act aims to provide reservation of up to 10% in public employment and in higher educational institutions for economically weaker sections. So, the EWS quota of 10% was introduced through the 103rd Constitutional Amendment Act. Now, the Presidential Order or the Executive Order which has been recently issued by the President aims to provide the benefits of 77th and 103rd Constitutional Amendment Acts to the people in the state of Jammu and Kashmir. So the central government has now said that the amendment will give benefit of promotion in service to scheduled caste and scheduled tribes, and it will also extend the 10% reservation for economically weaker sections in educational institutions and public environment. And now the centre's move has been challenged in the Jammu and Kashmir High Court. Now let us understand why is this challenged, or why is the amendment of the centre being challenged in the Jammu and Kashmir High Court. So major Jammu and Kashmir parties said that the order violated the Article 370 of Indian Constitution. So Article 370 of Indian Constitution confers special status to the state of Jammu and Kashmir, and this article also defines or regulates the relationship between Jammu and Kashmir with the Union of India. So Article 370 is a very important article which confers the special status to Jammu and Kashmir and which regulates the relationship of Jammu and Kashmir with that of Union of India. And the power of the governor to make recommendation without the concurrence of the state government has been challenged now. We have earlier seen that the governor's administration in Jammu and Kashmir recommended amendment to this order to the Union Cabinet, followed by which the Union Cabinet recommended the President to issue the executive order. Now, the challenge is that the governor has not consulted the state government before making such a proposal to the Union Cabinet, and the petition pleaded to the court in order to struck down certain provisions. That is, the first one, the Constitution application to Jammu and Kashmir order of 2019, that is the executive order, and second one, Jammu and Kashmir reservation amendment ordinance of 2019. Now if we look at a past example, in the year 1986 also an amendment to the 1954 order was issued, and this was also made in concurrence of governor's administration in Jammu and Kashmir. So in the 1986 executive order, it extended to Jammu and Kashmir Article 249 of Indian Constitution. So Article 249 of Indian Constitution describes the power of Parliament to legislate in the national interest even on matters in the state list. So this petition was also challenged in the court, and this case is still pending with the court. Now it is also important to know what were the terms of Jammu and Kashmir entry into the Indian Constitution. So when Jammu and Kashmir entered into Indian Constitution or Indian Union, what were the terms and conditions? In the month of October 1947, Maharaja Hari Singh, who was ruling Jammu and Kashmir then, he signed an instrument of accession in the month of October. So according to the instrument of accession, Jammu and Kashmir gave up the control over on three subjects: defense, foreign affairs and communications. So a separate constituent assembly of Jammu and Kashmir was planned in order to frame the constitution for Jammu and Kashmir. So Jammu and Kashmir has a separate constitution, and to work out the Jammu and Kashmir's constitutional relationship with New Delhi, a separate constituent assembly was planned. And under Article 370 of Indian Constitution, only two articles of the Constitution apply to Jammu and Kashmir. One is Article 1, which defines India, and the other one is Article 370 itself. So these are the only two articles which will apply to the state of Jammu and Kashmir from the Indian Constitution. So Article 370 of Indian Constitution provides that other provisions of the Indian Constitution can apply to the state of Jammu and Kashmir subject to such expectations and modifications as the President may by order specify. So any other provision of Indian Constitution, if needed to be applied in the state of Jammu and Kashmir, it needs an executive order of the President, or only President can make such modifications and exceptions. And here, what is the condition? The condition is that the President can issue an executive order only in concurrence with the state government. So the President cannot himself execute an order, but it has to be consulted with the state government, or only in concurrence with the state government. Any modification or exceptions can be made by the President for any provision in the Constitution of India with Jammu and Kashmir. Now let us understand what is a 1954 presidential order. The decisions to extend the provision of Indian Constitution other than those specified in the instrument of accession had to be ratified by the Jammu and Kashmir Constituent Assembly. So if any provision of Indian constitution need to be extended to Jammu and Kashmir, then it had to be ratified by the Jammu and Kashmir Constituent Assembly. But in 1954, the Jammu and Kashmir Constituent Assembly was yet to be set up. But even in such a situation, the central government or the union wanted to extend a few provisions of the constitution to streamline Jammu and Kashmir's relationship with the union. So, a presidential order was issued on January 26, 1950 itself with the concurrence of the state government. And on November 5th, 1951, the Jammu and Kashmir's Constituent Assembly was convened. So soon the 1950 order was replaced by the Constitution application to the Jammu and Kashmir Order 1954. So earlier in the year of 1950, an executive order was created because there was no Constituent Assembly. But later when the Constituent Assembly was convened, the order was replaced by the 1954 order. So this order applied to Jammu and Kashmir the provisions of Part 3 of the Indian Constitution that relates to the fundamental rights. And the 1954 order also introduced a new article, that is Article 35A, which protected the laws passed by the state legislature of Jammu and Kashmir in respect of permanent residence. So this provision was regarding permanent residence in the state of Jammu and Kashmir. And under Article 35A, any protections offered to the residents cannot be challenged on the ground that they violated any of the fundamental rights. And this order was ratified by the Constituent Assembly that also formed the Jammu and Kashmir Constitution before dispersing in November 1956. So the Jammu and Kashmir Constituent Assembly dispersed in 1956, but before that this order was ratified and Article 35A was created. Now let us understand what was the contention or what was the debate. The 1954 order had the requisite concurrence of both the state government and the Jammu and Kashmir Constituent Assembly. We have seen that the state government agreed and also the Constituent Assembly had ratified this order. But subsequently, 42 presidential orders have been issued and all of which were amendments to the 1954 mother order. So 42 amendments since then which tried to amend the mother order were issued. And through this 42 amendment orders, successive central governments had extended 94 out of 97 entries in the union list and 26 out of 47 in the concurrent list to Jammu and Kashmir. And through this 42 amendment orders, the central governments or the union governments have also made 260 out of 395 articles of the Indian Constitution applicable to the state of Jammu and Kashmir. But what is the contention here is that the 42 amendment orders, none of them had fulfilled the requirement of ratification by the Jammu and Kashmir Constituent Assembly. So 42 amendments were made to the 1954 order, but none of them were ratified by the Constituent Assembly. So for this, the central government has argued that an elected state government's consent is enough. So central government argues that the state government's assent was already taken before amending the order. In the year of 1959, the Supreme Court also observed that the constitution makers were anxious that the said relationship could be finally determined by the state Constituent Assembly itself. So the Supreme Court left the matter to the state's Constituent Assembly in the year 1959, but later the court ruled that the presidential orders could still be made through Article 370. So it happened in 1969. Again in 1972, the Supreme Court said that the governor is the head of the government which is aided by a council of ministers. So these were the Supreme Court orders. Now coming to the present order, can we justify the present order? The latest order only has the consent of the governor without the requisite aid and advice of the Council of Ministers. If we look into the previous Supreme Court orders, it says that governor is the head of the state but has to be aided and advised by the Council of Ministers. But in the present order, we will see that this has been proposed by the governor without the aid and advice of the Council of Ministers. So governor is only the nominee of the union government. So we cannot completely say that the proposal made by the governor can be taken as the proposal of the state government. So the debate here is that whether the governor meet the definition of the state government laid down under Article 370 and the definition that is given by the Supreme Court in its previous orders. And also there are many opposition from the major parties in Jammu and Kashmir to the amendments made in 1954 order without ratification by the Constituent Assembly of the state. You can find the PDF of this lecture on my Facebook page. And for more updates of my lectures, you can follow my Facebook page and you can also write to me at joyce.studyiq@gmail.com. Thank you.